Well, the Michigan Supreme Court just wrapped up its annual term, and it was a term full of very important decisions in lots of areas of law, including auto insurance and premises liability. It's a lot to digest, but here to break it down in the first of a two-part series, Tom Sinas. He's from the Sinas Dramus Law Firm. Tom, thanks so much for being with us.
Hi, Michelle. Thanks for having me.
Absolutely. So talk about these decisions from the Michigan Supreme Court, specifically with auto insurance.
Yeah, so there was a huge decision that was issued in the end of July, and I know you guys at Fox have covered this extensively. So let's maybe back up and ask ourselves, what was the controversy that led to this decision that really has been 3 years in the making? I think, as many people know, back in 2019, the legislature and the governor passed into law a No-Fault Reform Act that imposed a series of changes when it comes to our auto insurance. And those changes went into effect over a course of time, really in 3 phases. But the third phase was, I think, for most people, from a human standpoint, the most severe. And that phase started in 2021, when these very severe limitations on medical care began to be imposed upon auto accident victims. And the limitations were really twofold. It was a draconian and severe cut to reimbursement to victims' medical providers, a cut of 45%, and an arbitrary hour limitation on the amount that a family member could be compensated when they're caring for a loved one. And these reforms had been attempted to be applied by the insurance industry to those people who were injured before the law was passed. There are, of course, thousands of people in our state who are auto accident victim survivors, some from many years ago. But the insurance industry took the position that all of these reforms should apply to everyone, even if people had bought and paid for auto insurance policies before the law went into effect. And so the lawsuit, named after the lead plaintiff, Andary, as in Dr. Michael Andary and his wife, Ellen, the lawsuit began about 3 years ago, and it addressed this question of whether or not these limitations could be applied to those people injured before the law went into effect who were drawing benefits under their own auto insurance policies.
Okay, so you talked a little bit about the plaintiffs. Tell us, what did the court decide in the end?
So in the end of the day, the court said no. The court said no. These two kinds of limitations on care, the limitation on medical provider reimbursement and the limitation on compensation to family members, those limitations cannot be applied to those individuals who were injured before the law went into effect, and that day was on June 11, 2019, to those people who were injured before then and who were drawing benefits under auto insurance policies that covered them or their family members. In other words, the court recognizes here that these were individuals who were covered under existing policies, who paid their premiums with the expectation that they would have full reimbursement for their medical care. And the court said that this statute, passed in 2019, you cannot take those two limitations on care and provide it and apply those limitations to that group of people injured before the law changed and who were drawing benefits under their own policies.
Okay, so talk to us about, if there's a lot to digest, talk to us about the questions that are still left open today after this decision.
So there are and will be a lot of questions. This answered a lot for a lot of people. And it was, I think, a welcome sigh of relief for many people around the state. But there are a whole group of auto accident victims who are not affected by this ruling. I mean, most obviously are the people who were injured recently, who were injured perhaps at some point after 2019. This decision doesn't deal with that group of people. There are also people who were injured before the law changed who may have been drawing benefits in a different way than under their own auto insurance policies. And in this case, the court said, we're really not deciding that today, one way or another. But the biggest and I think most perplexing problem for us going forward is that our recent auto accident victims, those people injured this year, last year, unfortunately next year, these limitations on medical care, they would apply to all of us. And unfortunately, when it comes to this law, even though the law is heralded as one as having choices, there is no choice that allows any of us to select an auto insurance policy that provides full reimbursement to our medical care providers. We are all stuck with these limitations on medical care reimbursement if we're injured or an auto accident victim, unless the legislature changes the law.
Okay. Well, there you go. And so this actually has some special significance to your firm as well. Talk about that.
It does. This is a firm that, I mean, this is a case that our law firm has been handling for a number of years. We filed the lawsuit and it started in the trial court and it went all the way to the Court of Appeals and eventually made its way to the Supreme Court. And it's a long time coming for those of us who worked on the case. And here I really can't credit enough the incredible contributions of my father and our law firm's managing partner, George Sinas. This is his case really from the beginning. And of course, a lot of people worked on it along the way. But I think I can speak for him when I say that he chose to do it and the law firm chose to do it because it was the right thing to do. And because it's the kind of case that hopefully will have an impact on people's lives. And I think we will see that there are thousands of Michiganders whose lives will be improved by this. It doesn't solve all of our problems, and we still have a lot of work to do. But I think it's something that everyone can really be proud of, because I think all of us can kind of understand the idea that if we buy and pay for something, that the government should not be able to come into our lives and take that away from us. And that's really the bigger point of what this case stands for. So in that sense, it's good, but more work to be done.
Well, we appreciate all the work you've done to this point, and I know that it'll be a long road ahead. But Tom, thank you so much for your time. We really appreciate it.
Thank you for having me.